Yeah, so is my screen visible?
Yes, Pooja, please carry on.
Yeah. So, hi, good evening, everyone. This is Pooja Rawal from Omira IP, and today we will be discussing the fundamentals of IPR with special focus on patents. And as Sudeep has already briefed me, that the students need to know about patents, the basics of patents, because they are an integral part of their academic, academic year and their studies and their curriculum. So before we move on to patents, I will just like to, first of all, we are talking about intellectual property here. So all of us should have a very clear understanding of what intellectual property is and what it means in the truest sense. So just the way the property is a tangible asset owned by anybody, and it has some value attached to it, and it can be transferred, it can be sold, bought. So similarly, intellectual property is also a property in the true sense, and it can also, you can do everything that you do with a tangible property with the intellectual property also. So so to say, intellectual property can be sold, it can be bought, it can be transferred or licensed or leased, and yes, some people can take ownership of it. And as the name suggests, this is a property that comes out of the intellect of a certain person. So in what all intellectual property includes, I'll quickly cover that also. So patents, trademarks, copyrights, industrial designs, trade secrets, and geographical indications, all these are different types of intellectual property which which provide protection for different kinds of property actually. Trademarks protect the brand names or the trade names. So whenever one comes up with a company name, registers a company, the name of the company can be trademarked. The unique products, if you want to name your products uniquely, that can be trademarked. So Amul is a registered trademark, Nike is a trademark, Bata is a trademark. So all these are trademarks, and they have become the identity of the company. And similarly, one company can have several products, and each of those products, if they are unique in their sense, they can have different names. So this is about trademarks very quickly. Copyrights, they protect artistic works, and things like poetry, songs, lyrics of a song, the musical composition, books, lessons written in with respect to the faculties, and faculties also attending lectures or the curriculum that are designed by professors, they can be copyrighted. Lectures and webinars like the way we are having a webinar right now, all these can also be copyrighted. Of course, websites are copyrighted, and codes, the code, the algo, not the code of the software also copyright protects. It protects any form of expression. Then industrial designs. So I'm just briefly touching upon various topics which come under intellectual property, and then we will focus and discuss in detail about patents. But if there are any questions, please feel free to interrupt and ask me. So industrial designs, they protect the outward appearance or the design of a certain product. So if a product is unique in terms of its structure, the way it is made, and that structure also gives it a unique function, then that will not be protected through an industrial design. But if the outward appearance of the product just gives it a unique look and an aesthetic appeal, that can be protected through an industrial design. So basically, you can have a product. Let's suppose somebody designed a drone. Now the drone may have certain unique features which make it function better or improve its efficiency. So those features can be protected through a patent. And whereas if you come up with a very unique design of the drone also, that can be protected through an industrial design application. So it's very much possible in engineering that products can products can be protected both by a patent and an industrial design, and both of them need to go in parallel. Now, let's also discuss trade secrets. Trade secrets, as the name suggests, are secrets. They are not disclosed in public, unlike the patents. And so, one why people would opt for trade secrets is when they feel that the subject matter or their invention may not be patentable enough. It may not lead to a grant and enforcement of the patent. And so in that case, in the best interest of the person or the company, they may decide to keep it a trade secret. But keep in mind, this is a very risky option because since trade secrets are not revealed to the public, if somebody else files a patent on the same invention, even though you have been working on it and exercising it for a very long time, but just because they have filed a patent, they can stop you from exercising, manufacturing, selling the product, or practicing the invention per se. So trade secrets have their own risk, but sometimes trade secrets are a good option also. One classic example that I can quickly give is of the Coca-Cola composition, the Coca-Cola drink, the formulation, and the exact ingredients and their ratios which make up the drink. It has been kept as a trade secret for many, many years by the company. So, because the patent enjoys a monopoly only for 20 years. So, if the company or the inventor wants a monopoly for more than 20 years, then he can opt the risky path of keeping it as a trade secret also. So the next few slides talk about these IPRs in detail. What are the good practices of a trademark? So I will be skipping all these, and we will be moving on to patents because I guess that is what is of more interest and importance to today's audience. So let's discuss patents in detail. So, as all of you might be aware of, patents are granted for inventions. And let me just explain briefly what we mean by an invention in the patent language. So, what we mean by an invention in patent language or by the patent law is an invention which solves a problem, and the problem needs to be technological. So whenever there is a problem, a technological problem, and that is solved by some solution, that solution is what can qualify for a patent. Sorry. Having said that, first of all, let me make it very clear that though we say that the only absolutely unique, noble, inventive inventions will be granted a patent, no invention in today's date is absolutely unique. All inventions are implemental in nature. So let's suppose a person has designed a machine. Maybe some years down the line, another person makes it even better by adding some additional feature to it, or by or by tweaking the process slightly. So even that qualifies for a patent. So first of all, it's not that you need to be come up with out of the box. You need to do out of the box thinking and always come up with absolutely unique ideas. No, but if your ideas are unique and substantial enough that they bring a great change in the way a particular machine works. Let's suppose its energy efficiency improves. Let's suppose it becomes more eco-friendly, or it functions better. The time that it takes to do a certain task decreases drastically. So all these changes can also become reasons for patentability. So, just to summarize, there are three criteria for patentability which are accepted worldwide. Though we have patent laws which are specific for different countries, like India has its own patent law, there is a different patent law for US and Europe and so on. But globally, there are certain criteria which have been accepted by all countries, and these three criteria, which are most important and should be remembered, are first is novelty. The second is inventiveness or non-obviousness, and the third is industrial applicability. So please keep in mind these are three patentability criteria. So whenever anybody is working on a certain project and he is doing some research, he needs to question himself on these three criteria. That is my invention novel? Is it inventive, and does it have any industrial application or not? Now we will be discussing each of these in slightly greater detail. But before that, let me just summarize that patents are granted for products and for processes. Methods of use patents are not granted in India, as the Indian patent law does not allow them. But yes, in US and Europe, method of use patents are also allowed. So in today's date, any product can be patented, a process. The product may be the same, but you may come up with a unique process of developing that product. And then in that case, the process can also be patented. Lastly, the term for patents is 20 years from the date of first filing. The date of first filing is also called as priority date. So always keep in mind that the term of the patent will not start from the date of its grant, but it will start from the date of its first, when it was filed first. Okay, so let's suppose we file in India, on 28th July 2021. So the term will start from today itself. So that's about the term of the patent. Now coming back to the criteria for patentability, let me just explain the novelty criteria of patentability with an example. So now let's suppose there is a there is a cough syrup formulation, and this cough syrup formulation has four ingredients A, B, C, D. Okay, and it is known to have a certain effect on treating cough, and it is marketed and it is also patent protected. Now let's suppose another company or the same company now, after some experimentation, adds a fifth component E to it. Okay, now and there is no other cough syrup formulation which is disclosed on a global scale which has all these five ingredients together. So now if such is the case, that there is no mention of such formulation with A, B, C, D, and E together, then yes, the novelty criteria for patentability is met. So if I want to give another example, if there is a machine which has five parts to it, and you add a sixth part to it, and there is no other machine which has all these six parts combined together, then yes, the criteria for novelty is met. So as you can imagine, the criteria for novelty is not very difficult to achieve. It can be achieved. Now the next and the most crucial step for patentability or the criteria is inventiveness or non-obviousness. Now what it means is, going back to my earlier example of the cough syrup formulation, if E was also known to have a certain effect independently on treatment of cough, okay, and there was some evidence for that, and I already had this formulation with A, B, C, and D. Now I have just combined the knowledge from these two things together, and I have made up a formulation A, B, C, D, E. Now if this is the case, then the patent office will say that this was very obvious in light of the prior art that was already available, the literature that was already available. So this is not inventive enough. This is what the patent law says. So whenever you come up with a solution, unique solution, it needs to be non-obvious. It needs to be something which is not very apparent because of the literature that's available globally. Now, having said that, there is another, you can imagine another scenario if E, on being added to A, B, C, and D, brought out an effect which was much more than what could have been anticipated. Then yes, you can argue that no, E is having a surprising effect, and that's why my invention is inventive and non-obvious. To give another very silly example though is, let's suppose I make lime juice and water and sugar, I end up making lemonade. Okay, now let's suppose on adding a fourth ingredient, I add some kind of salt, let's suppose, and by adding that salt, if I'm able to get a strawberry flavor, okay, then this is something that's surprising, that's non-obvious, and this will qualify as being inventive. So something that's not very apparent or cannot be anticipated by the known prior art, that is what will make your invention inventive. Now this is the most crucial and most argued criteria for patentability. Most patent offices come back with reports saying that your invention is non-inventive on similar grounds. And there are 2-3 factors which can help you succeed in proving that your invention is inventive. First of all, yes, the invention needs to be indeed having some uniqueness to it. And secondly, the drafting, the quality of the draft, or the way the inventiveness is brought out in the patent, is what will help you greatly in proving to the patent office that no, my invention is inventive. Though there are certain prior arts hinting towards it, but I have kind of brought it to a solution. I have excised it, and there are certain results which you can show in the patent application. So So basically, these are the two most important criteria for patentability. That is, first is it needs to be novel. So the moment you add one extra feature to your existing product or process, and there is no process with all the features combined, let me just make it a little more clear. Let's suppose there was a formulation having A, B, C, D, and there was one formulation having E, F, G. Okay, and now you have made a formulation with A, B, C, D, E, and F, and no such formulation was known. In this case, also your formulation will be novel. So the moment all the features put together, the combination of those features, if it is novel, if it has at least one unique feature, then yes, it is novel. So the first criteria is met. The second criteria, non-obviousness or inventiveness. This takes a little bit of, it's a tricky thing and it needs to be proved. Any questions so far? Hello. Yeah, okay. So let's move on to the next slide. Yeah. So having said that, so once somebody comes up with a patentable idea, and he feels that yes, my solution or the product that I have developed is looks novel, and I have not come across any prior art, be it a patent or a research paper, or it could be a video, it could be a product brochure, anything which explains exactly the same product or process. Then the next step is to do a patentability check, a patentability assessment. Now let me explain what patentability assessment is. But before that, please keep in mind patentability of any invention is a global criteria. That means that even though you are filing for a patent in a certain country, let's suppose in India, the invention needs to be patentable on a global level. So it needs to be unique, it needs to be novel, globally. So there should be no disclosure. When I say no disclosure, it means neither a research article nor no presentation, no research article, no patent, of course, and no video, nothing, no disclosure which gives exactly the same solution as what you are offering. So in order to do a patentability assessment, one needs to first of all break down the invention into keywords, and you need to do a very thorough search of these keywords in patent as well as non-patent databases, and try to find out which are the closest prior art, which are the closest references. And once you gather these closest references, you need to very critically check how similar or dissimilar they are from your invention. So only when you do this thorough global search and do a comparative study, you will be able to assess whether it is patentable globally or not. So this is about patentability assessment, and though there are several patent databases that are freely available, like Google Patents, USPTO, eSpaceNet, but still, since patentability aspect is checked globally, most often when one does a patentability assessment using these freely available databases, there is a high chance of missing out on certain prior arts, because many patents are still could be there in the paid databases. So a very thorough check needs to be done in order to confirm the patentability of any invention. So once the patentability assessment is done, and let's suppose it shows that the invention is indeed novel and inventive, then one can go ahead with the drafting and filing of the patent application. Now here, let me also discuss another scenario wherein what if the patentability assessment report is negative? What if we find out that no, there are, I was not aware, somewhere in Russia or Japan, there is this company which has also developed a product which looks very similar to my product, and it has almost the same features. Now in such case, what do you do? So in such case, there are two ways to go about it. First is, you decide that okay, we will not file a patent. Okay. Another way is, what you can do is you can brainstorm and see that now I know that this is the closest prior art that I have, with my invention. Now you can brainstorm and check what extra features can you add to your existing invention, to make it still unique, to make it different from what is the closest prior art is offering. So that kind of a brainstorming session can be held, and you can come up with some additional features. And please keep in mind, these additional features, it's not necessary that you work out everything in the lab or you develop a prototype always. It can be something that it should be a workable solution, but it can be something that you've not tried, but there's a possibility of adding to it. So those things can also go into the patent application. So most often people get confused that whatever solution they are offering, they want to protect only that. But a patent is good for 20 years. So you need to think, what more changes will I be making in my product or process in the next 20 years or in the next 10 years? And all those changes also need to be incorporated in your patent right now. So basically, we get a very broad protection of our invention, wherein so we do not allow somebody to make minor change in our invention and still evade our patent, and they are able to work around and exercise it. If we want to enjoy absolute monopoly, we have to really think 360 degree on the solution. We have to think what different features can be added in totality, even though you have not worked on them right now, but what more can be done. So whenever we say a salt or we say a polymer, we don't very precisely say which polymer or which salt. We generally give a term like a polymer or a salt, and we give certain examples that the polymer can be this or this. So any polymer having similar properties or any salt having similar properties can be added. So that's about patentability. That patentability assessment is a must. One should always do it before proceeding for drafting and filing a patent application. And a patentability assessment, even if it is negative, first of all, it will help you give a very clear idea of who are the closest competitors, or who are the inventors who are working on similar solutions. And that could be useful to a person in several ways. One could collaborate with the person, one could just gain some more information as to how that person has dealt with the problem, what solution he is offering. And finally, you can also make certain changes or add more features to your existing invention to make it still patentable. So this is about patentability assessment, which is very, very helpful, even if it is negative. And once this is done, one can go ahead with drafting and filing a patent application. Now, before we discuss about the patent system in India and how filing is done and all that, I will just briefly explain what are the different sections of a patent application. So whenever you open any patent application, whenever you look at any patent application, you must have come across these sections. And the reason I'm explaining you these sections is so that firstly you understand and appreciate patent applications better. When you read them next time, you're able to make more sense out of them. And also so that you realize what significance each section holds. Because sometimes to a person who doesn't have much knowledge about it, may seem that the same thing is being repeated again and again in the application, and you may feel confused as to why this is being done. So patent application drafting is very, very different from drafting research articles. Drafting research articles, I would say, is pretty straightforward, and you just need to give a background of your research area, and then you can start explaining your own work, give experimental data, give a conclusion, put some drawings, and that's it. But a patent application is a techno-legal document. It should always be drafted keeping in mind the patent law of the country in which that application is going to be filed. So there are certain specific differences in patent laws across the globe. Indian patent law is different from the US patent law and the European patent law, and so on. So one needs to keep in mind the law, the sections of the law, what is allowed, how it is allowed, and that's how the patent application should be drafted. So the various parts of the patent application are: the first is the abstract. Now the abstract is very, very important important in the sense that the abstract gives a very short introduction to the invention, and what it tries to highlight or bring out is the field of invention, the area in the technological area, which the invention is talking about. Now this abstract is very important. Why? Because patent applications, when they are filed and later on when they have to be assigned by the patent office to different examiners, they generally just look at the abstract and they try to find out which is the technological area and accordingly they assign the patent to the examiner who is skilled in that particular area. So imagine if the abstract is not able to bring about the field of invention very explicitly, then it may end up to an examiner who is not skilled or who is not qualified in that area, and that would be disastrous. So the abstract is important in this very short sense that the abstract should bring about very clearly it should talk about the field of invention. Now the next section is background of invention. Now, background of invention, as everybody might be aware of, is it talks about the
Excuse me, ma'am.
background. Yeah.
Ma'am, in abstract, there is any limitation of the number of words or the sentence that has to be used?
Generally, it needs to be small. It can be maybe a maximum of I would say 100 words, not more than that. So it is very brief.
Okay, thank you.
Okay, it will not talk much about the invention. It will just discuss the area that this is about a pharmaceutical composition, treating such and such things and that sort, something of that sort. Okay. Now the background of invention is very important because this is the place where one can tell their story, one can tell discuss the problem first of all, for which one is offering a solution. So you can discuss let's take the example of COVID-19. Let's suppose there was a COVID-19 a patent on a medicine that treats COVID-19, certain symptoms of COVID-19. So in that case, the background of invention would talk about infectious diseases first, then converge towards viral diseases caused by viruses. The problem with viruses, maybe it will converge upon the SARS family of viruses, and then discuss COVID, coronavirus in general. Then it will talk about what are the solutions that are already available. Okay, what limitations each of these solutions have. So here you can cite patents as well as non-patent references. I would not say that one should go overboard about it, but yes, some critical references can be cited here. So you can say that such and such patent offers this solution. Okay, but you will also need to state what are its limitations or what is the unmet need. Okay, so basically what you're trying to do in the background of invention is you're trying to explain the problem, how big the problem is, and what solutions have been available so far, and how those solutions have been insufficient. And that's how you will try to convince the examiner that yes, there is a problem which has not been solved completely, and then you will the later part of the patent you will be describing your solution, which should be solving that problem. So basically, it's a storytelling kind of a thing where you are discussing the background of the invention, the solution that are available, what their features are, what their limitations are, and then slowly you talk about the invention in the next section, not in the background of invention. The background of invention will never discuss the invention, your invention. It will only discuss the background. Okay. Now the next section of the patent application will be the description. Now this is the part where you will be discussing your invention completely. So all
Excuse me, ma'am.
details. Yeah.
In background of invention, can we
Yes.
state the need of the particular invention for the problem?
Yes, of course. Yes, you should be doing that. Yes.
Okay, thank you, ma'am.
Yeah. Yeah. So the description, you can describe your invention in detail. The description can include if you've done some experiments, those experiments can also be included, and the results can be, you can include tables in that, some figures. Drawing will not go into the description, but everything that needs to that has to do with the invention will go in the description part. It can be explained, and please keep in mind that whenever we are trying to protect a certain invention, there's a term called as sufficiency of disclosure. That is, a disclosure should be sufficient enough, and patent applications should be enabling. That is, when your patent, let's suppose you are granted the patent and your patent enjoys the monopoly for 20 years. After 20 years, anybody who reads the patent application should be able to replicate the work. That's the basic idea. So the description needs to be enough so that somebody can do that. Otherwise, examiners will question that also, that it is not sufficient. So one should not be secretive. People try to do that they try to play a little smart by giving some information and keeping some critical information with themselves. Sometimes it may be necessary, but I would say that on a larger extent, one needs to give sufficient details of the invention so that it can be replicated. Okay, so this is an important thing that one should keep in mind while drafting the patent application. Now, the next part is the claims. Now, the claims is the most important part of the patent application, I would say, and the claims are written in a very typical language if you've read them, and it's a much of a more of a legal language than a simple English language. Certain terms need to be used. For example, there's a difference between the terms consisting and comprising. So, and different patent offices globally also prefer certain terms. So there's a very typical I would say a jargon that is used while writing the claims, and that needs to be kept in mind. Secondly, the claims, whatever rights you want to get, or whatever monopoly you want to get for your patent, all that should be there in the claims. So though the claims are very concise, but still they need to cover all the features of your invention. Okay, and at a later stage when the patent gets examined, the most of the the most of the discussion and the prosecution revolves around the claims. You may have to amend certain claims, you may have to delete certain claims. All these things happen with the claims. So basically, whatever rights one gets for the claims. If you have said certain, if you have mentioned certain features in the description, but they have not been brought out in the claims, then you will not get protection for them. And you cannot argue saying that no, they were there in the description. So whatever you want to protect, it needs to be clearly brought out in the claims. Okay. Secondly, claims are chargeable. So every patent office allows a certain number of claims for free, and beyond that, if there are more claims, then there is a charge per claim. So one needs to keep that in mind. So one needs to prioritize and very clearly think that what is the core of my invention, what is the crux of my invention, and that needs to be very strategically brought out in the claims. So claim writing is the most tricky and technical part of the patent application drafting, I would say. So special attention needs to be paid to that. Then also, as I said, that whatever you said in the claims should also find sufficient what should I say, sufficient supporting literature in the description. So the examiner can also say during examination that you have mentioned this in the claim, but this is not mentioned explicitly in the description. So the description and the claims, they need to be very closely linked, and they need to cover what each one of them is saying. That needs to be covered very nicely. Then the last part is the summary of invention. This is simply, it just summarizes the invention, and it doesn't have much of significance otherwise, but will just be give a brief summary of what the invention has been and the technological area. Now the last part is the drawings. Now these drawings are also very important because many a times including drawings helps the examiner in understanding the invention better. There is a certain format that is prescribed for the drawings. The drawings need to be in a certain format. The size of the drawings, they need to be the contrast in the drawings. All these things are very specific for patent offices, and many times objections are raised only on the formats of the drawings. So one needs to pay special attention to them also. The numbering of the drawings and the way they are labeled. All these things need to be kept in mind. But yes, having drawings, especially for engineering patents, drawings are a big help because they help the examiner in visualizing the invention and understanding it better. So So that's about, these are the main elements of the patent application. So my intention of discussing this with you was firstly, so that when you read patent applications after this webinar, you should be able to, appreciate and understand them better. And secondly, if anybody tries their hand at drafting the patent application, they should also keep these things in mind. Although my suggestion would be that, patent application should be drafted by professionals who know the patent law well, because a patent, I always say, is a frozen document. Once you draft a patent and file it, then it stays for a very long time with you, and you cannot make much changes in that. So whatever the fate of your patent will depend upon how it has been written, how it has been drafted. So so if one really wants to protect a certain invention and get a grant and monopoly over it, then one needs to consider the drafting also very seriously. So that's about the elements of the patent application. Now let's also discuss what are the different types of patent applications that are that can be filed. So the patent application that can be filed are of two major types, I would say. One is a provisional patent application, one is a complete patent application. Now let me firstly explain provisional patent application. A provisional patent application can also be called as a temporary patent application. And what it does is, let's suppose you are working on a certain area, and you feel that I have come up with a unique process, or I've developed a unique process, or a unique algorithm. And you also run a risk that this is an area in which many people are working, and those people also might be working on similar solutions. So you want to protect your idea as early as possible, but at the same time your idea is still quite raw, and you need to work more on it and develop it into a complete product. Now in such situation, what you do is you can file a provisional patent application. Now a provisional patent application will not be examined ever, and it will not be granted also. What it will do is it will only preserve a date for you. So let's suppose I file a provisional patent application today, and then I what I get is I secure today's date as my date of first filing. So the first advantage that I get is anybody who files a patent on the same invention after me, after today, his patent will not be granted, and I will be given the preference because I have been the first to file. So the date becomes very, very important in this sense. Secondly, I get 1 years of time from the date of my provisional patent filing, in which I can work on my product or process, complete it, and file the complete patent. And this complete patent will also have the priority date of the provisional patent, firstly. And this complete patent can then be examined and granted. So provisional patent, first of all, never gets published, it never gets examined, and it will never be granted. If a provisional patent is not followed by a complete patent within the stipulated time, it will be lapsed. Okay, so it is, you can say, it just remains with the patent office until you file the complete patent application. But yes, it secures the priority date. I'll give you a very realistic example of how people have been using provisional patents. So first of all, in moving technologies that are developing very fast, so people always run this risk that our competitors might file a patent, and by filing the patent they not just get the rights, but they can also stop you from exercising that. For example, if your competitor files patent for the same invention in India, then first of all you will not be able to file a patent, that's one thing, but you will also not be able to exercise your invention because your competitor has filed a patent on it, and if it gets granted, so you will not have the freedom to operate also. So patent filing at its date becomes very, very important. Secondly, what we saw during this COVID period was that many of our life sciences and biotech clients, they came up with various ways of testing the COVID antigen, basically RT-PCR or some other methods. Okay, and the moment they felt that yes, they have some unique way of doing it, they quickly secured themselves by filing provisional patents. Now, provisional patent need not have as many details as you need to have in a complete patent. First of all, so it can just be a short summary of the invention. The claims need not be there in a provisional patent, so you can just give very few details of your invention. What problem? What is the problem and what solution you are offering without saying much about the solution. So that is all that goes into a provisional patent. So our clients, they file these provisional patents, and now, 1 year down the line, they realize that already the market is saturated for such kinds of tests. So many of them have decided to drop their provisional patents. Okay, so they are not pursuing them further. So sometimes this is also one strategy, that you just file a provisional patent and see how the product or the process develops, and then decide whether it should really be pursued as a complete patent or not. Because the complete patent, once filed, it will undergo examination, and it will have to be maintained for 20 years. So whether your business interest lies in that product or process or not, you can judge that also within this 1 years of waiting period. So that's the importance of the provisional patent. Complete patent, of course, is a patent which will be, when the examination is requested, it will be examined and can be granted or refused. Then next is convention patent and PCT. Now these are pertaining to foreign filing, that is filing outside the home country. We will discuss that in the next slide. Now let's also touch upon patent of addition and divisional patent. Now both of these are patents that can be filed when you have some small incremental changes in the invention for which you've already filed a patent. So let's suppose you have filed a patent for a certain machine having a certain number of features. Okay, and now you have made some more changes to this machine in the next 1 or 2 years. Now these two changes may not be enough for you to file a new patent, a fresh patent altogether, but yes, they are significant enough and you want to protect them. Then, in order to protect them, what you can do is you can file a patent of addition, and this patent of addition takes reference from your older patent, from the complete patent. So, it will refer to that and say that this is a part of that invention, and has been added now. And the term for this patent of addition will go along with the term for your complete patent. So it will expire with your complete patent. It will not have a separate term actually, because it is a part of the older invention. So that's the advantage of a patent of addition. A divisional patent, sometimes one invention which you think of as a single invention may have more than one inventive concept. In such case, a divisional patent can be filed. So these are the different types of patent applications that you can choose from. So depending upon where you are in your research, what kind of invention you have, and whether you feel it's complete or not, you can choose from filing a provisional patent or a complete patent, and later on you can file a division or a patent of addition also. So let's just quickly discuss the patent system in India. So what happens? Let's suppose you drafted and filed an application. Now, after doing so, the patent application will get published in the official journal after a waiting period of 18 months. So let's suppose you filed a patent 2 months back and you are checking the IP India website, you will not find your patent. And please don't be surprised, because the Indian Patent Office has a mandatory period of 18 months of waiting. So all patents, so the one more side of this is, when you do a patentability check also, you will not be able to see patents that were filed less than 18 months ago. That's the downside of this also. So publication happens on its own, but it takes a waiting period of 18 months. Now, if somebody wants their patents to be published early, you can do that. You can file what is called as a request for early publication, and there is a certain fees that you need to pay to the patent office. And by doing so, your application can be published within 1 or 2 months of requesting for it. So after publication, the examination will only start after publication, first of all. And for the examination also doesn't happen by default. One needs to request for it. So you need to file request for examination, and after doing that, the examination begins. In the examination, the examiner will do a thorough worldwide search, come up with the closest prior art and issue a first examination report. This report will mention first of all inconsistencies in terms of the drafting style or the format. If there are any, all those will be reported and you need to correct them. Secondly, if there are any closed prior arts because of which your invention, the examiner feels that your invention is not novel or not unique, that will also be pointed out in the examination report. Now, there is a time of 6 months from date of issue of first examination report, in which one can analyze the FER and prepare a response and file it before the Indian Patent Office. One can do it earlier than 6 months also, but the timeline is 6 months. Maximum period is 6 months. Now, once you file a response to the office action, the examiner will go through it, and if he is convinced, he may issue a notice of grant for the patent. And if he is not convinced, he can issue another examination report, or he can call for a hearing. Now, the hearing generally happens through video conferencing these days. So there will be a virtual hearing where the agent and the applicant, they can speak to the examiner and put forth their points and have a open discussion. And after the hearing, again a written submission needs to be done, wherein the applicant or the applicant's agent will again prepare a response citing all that was discussed during the hearing and giving them their arguments and defense. And finally, once the examiner is convinced with that, the written submission and the amendments that you've made to the application, then the certificate for grant is issued. Now, normally this period for I would say in today's date, it takes at least 3 to 4 years time, right from the date of application to getting a decision on the patent. It will take at least 3 to 4 years time. And please keep in mind that before 2016 or 2015, this used to take easily, it used to take 8 to 10 years time. So the Patent Act has been revised in 2016, and large number of examiners have been added now. So the process has picked up speed, I would say. But yes, still it takes easily it will take 3 to 4 years. So if one wants to expedite it, one wants to get a quick decision on the patent, then what one can do is one can apply for expedited examination. Okay, now this expedited examination needs to be requested, and a certain fees needs to be paid. And secondly, this option or facility is not available for every field in India. Okay, so the next slide will discuss Patent Office. Segregates applicants into 3 different types. The first is individuals or startups or MSMEs. This is one type of applicant that the Patent Office recognizes. The second is your smaller companies, and the bigger public limited companies fall under the others category. So these are the 3 types of applicants, and this expedited examination route is available for either startups, because the Indian government wants to promote the startup ecosystem in India. So startups are given this facility, or else the women applicants. So let's suppose you're filing a patent in your name and you add a woman as a co-applicant. Then by adding that woman as a co-applicant, also you are eligible to apply for a fast track examination. So these are 2 ways: either startups or companies with women as co-applicants. Both of these are eligible for applying for expedited examination, and by doing that, you can expect a decision on your patent within a year's time, a maximum time frame of 1 year from date of filing. So you can expect a decision, a grant on it. So that's how quickly it happens. The fees also is in all these 3 criteria categories. The fees is also lowest for startups or individuals, and it keeps on increasing as we go for small entity and others. So this is about the cost for patent filing. Let's also quickly discuss foreign filing and PCT. Now, let's suppose you have filed a patent in India, and so then there are certain timelines that you need to keep in mind if you have any plans of filing outside India. Now, first of all, let me also discuss as to why should or when should one decide to file one's patent application outside the home country. So let's suppose we have a very localized, a product which has a very local demand, and okay, specific to your home country, and the scale of your operations is also small, and you have no plans of growing it on a very big scale such that you will export your product anytime, then in that case you can stop by at filing in India. Okay, and you need not worry about filing outside India. But let's suppose you have plans of taking your product or exporting your product, let's suppose outside India, or you want to find collaborators outside India. In that case, it's important to protect your invention outside India also. And for doing so, there are certain timelines that should be kept in mind. Now, first of all, from the date of first filing in the home country, you get a time period of 12 months, maximum time period of 12 months, in which you can file in any country of your interest. So let's suppose I filed a patent in India today. So within 1 year from today, I have to decide which countries I want to file in, and I should do the filing in those countries. Now, foreign filings, first of all, are very expensive because it involves foreign attorneys. You need to have a local attorney, you know. Then certain countries may require you to translate your patent application. For example, China, Japan, Russia, you will have to translate the entire application, where the translation fees is calculated on a per word basis. So the translation fees is generally quite high. You need to pay the fees of the local patent offices. Okay, so all these things add up to the total cost of filing in any country. Now, a period of 12 months may be very small for somebody to be able to take such a decision as to where one's business interest may lie in, firstly, and it also may be very less for one to gather funds for the foreign filings. Okay, so this is one route, but certain companies which are which have their registered offices in outside India, and they know where their business lies in and where they need to have protection, they can opt for this route because they are very sure of the choices to make. Now, if one is not very sure, then one can adopt the PCT route. The PCT route is also called as a patent cooperation treaty, and this is a treaty that has been signed by several countries globally. And by signing this treaty, what they have agreed upon is that they will give whoever files a PCT application will get an additional time period of not 12 months but 30 months from date of first filing. And before the expiration of these 30 months, one has to file in the country of interest. So basically, your timeline moves from 12 months to 30 months. You get additional 18 months of time to decide which country you want to file in. Now, so this PCT application, there is a certain fees associated with it, so one needs to bear that fees. And the PCT will also not give you rights in any country. It just helps you in buying extra time, extending your timeline. So that's the sole purpose of filing a PCT application. And then before the expiration of the 30 months, one can file in the countries of interest. So that's a big enough time period for one to assess the business, see how the product is doing. Also check, by that time, within 30 months, if the Indian prosecution happens, then they will have some idea if the patent is granted and how it is doing. So, one can take a decision based on that. So that's about foreign filing. Since we have students and faculty members today, let me also discuss the Startup India scheme, because students can form startups once they graduate, once they have finished their education. So who can apply for a startup certificate is any company that is less than 10 years old. A single person can form a startup, two people together can form a startup. Only criteria is it should be less than 10 years old. The turnover should be less than 10 crores, and it should be an original entity. So a branching of a bigger company into a smaller company will not be considered as a startup. It needs to be an original entity, and the area of work needs to be innovative and scalable. If one meets all these criteria, and if you develop a certain product or a process, then you can apply for a startup certificate. This is the link for that. It's pretty simple procedure. They will take some information about your product and your company, and they will guide you. And why one should go for startups or register for startups is because firstly you get a lot of benefits from the Indian Patent Office, and secondly the startup ecosystem is being really boosted in our country. There are several incubators which are welcoming the startups, providing them with all the facilities including the space, They provide them with mentorship. They help them connect with other startups or other companies, investments. And also, basically what they'll do is they'll hold the hands of the startup and they will help the startup, develop their idea into a real product or a service. So that's what the benefit of registering as a startup is. Another other benefits are there's a lot of tax exemption, and as I said, mentorship, connecting with investors, everything happens once you are registered as a startup. And you can participate directly in government tenders also. Let me just give you one example. One of the startups that we are working with in Mumbai, who is developing drones, they were able to provide their drones for surveillance in the slum areas in Mumbai last year during the second wave. Yeah, so that's it. Any questions?
I have a question, ma'am.
Yeah.
Yeah. What is the difference between patentability assessment report and the first examination report?
Patentability assessment report is something that you will be doing. Yeah, so patentability assessment report is something that one can, first of all, it is not mandatory. It is something that you will be conducting. It's like a due diligence that you will do before going ahead with the drafting and filing of the patent. So you will be, searching for it. Whereas first examination report, once the patent is filed and requested for examination, the patent office will conduct a search, okay, and they will form this report. And this report will have much more information. They will comment on all the, as I said, all the inconsistencies in the drafting of the patent also. So if there is something that has not been drafted properly, the claims or the figures, all those things will be pointed out in the first examination report, and one needs to reply to that in order to get a grant. So patentability assessment is optional, I would say, but it is recommended before you start drafting, before you even think of filing or drafting the patent. And FER or first examination report is something that is issued by the patent office after examination. Is that clear?
Yes, ma'am. Thank you. Yes, ma'am.
Yeah. Any other question?
Normally 7 game you have to, like, if you lose 4 games, you're out. You continue loss also. Do we have more questions?